This is Sam Stark, and in this video we are looking at voluntary manslaughter and loss of control. So first of all, we'll have a brief look at manslaughter, as manslaughter is a less serious form of homicide than murder, and there are two kinds of manslaughter. So there's voluntary manslaughter, which are killings which would be murder but for the existence of defined extenuating circumstances, and then there is involuntary manslaughter, which are killings where the defendant does not intend to kill or cause grievous bodily harm, but there is sufficient fault to justify criminal liability. But today we'll be looking at voluntary manslaughter, and in particular we'll be looking at loss of control, as an extenuating circumstances and a type of voluntary manslaughter include a defendant who successfully pleads loss of control. Now there are other things they can plead, such as diminished responsibility, but we will look at that at a future time. So loss of control is a defence only to murder, and if successful, the defendant will still be guilty of manslaughter, which means that it's a partial defence. So this means that you cannot use it as a defence to manslaughter, as it is only a defence if somebody is murdered. Now the defendant must show that they had lost self-control, but loss of self-control was caused by a qualifying trigger, and a person of a defendant's age and sex with a normal degree of tolerance and self-restraint would have acted in the same way. Now this can all be found within section 54 of the Coroners and Justice Act 2009. In cases other than murder, like assault, loss of control may be considered when deciding the appropriate sentence, but it is not deemed to be a defence. Now, section 54 of the Coroners and Justice Act also states that it does not matter if a loss of control was sudden, and if sufficient evidence is adduced to raise an issue of loss of control, the jury must assume that the defence is satisfied unless the prosecution proves beyond reasonable doubt that it is not. So now we will look at the three different aspects, and the first of these is the actual loss of the self-control element. Now this is because the need to show that the defendant lost self-control is a subjective question, and the jury need to look into the mind of a defendant rather than consider whether a reasonable person would have lost control. Now in the case of R versus Jewell 2014, loss of control was said to involve the loss of ability to act in accordance with considered judgment or a loss of normal powers of reasoning. So this means that a sustained and calculated attack is unlikely to constitute a loss of self-control. And this can be shown by section 54 subsection 4 of the Coroners and Justice Act 2009, which says that if a defendant acts out of a desire for revenge, the defence is not applicable. Even so, in R versus Dawes 2013, Lord Judge explained that provided that there was a loss of control, it does not matter whether the loss was sudden or not, as a reaction to the circumstances of extreme gravity may be delayed. So this means that a defendant may be able to rely on loss of control even if a qualifying trigger occurred sometime previously. Now, whilst many cases will deal with the anger of a defendant, there is no requirements of anger, and a loss of control through fear or moral outrage would also be possible. The next is loss of control has to be the result of a qualifying trigger. So as well as showing loss of control, the defendant must show that they were provoked by a qualifying trigger into losing self-control. In the case of R versus Acott 1997, where the defendant killed his mother in a frenzied attack, there was clear evidence that the defendant had lost his self-control and killed, yet there was a lack of evidence as to a reason for this loss of self-control. So this meant that there must actually have been a reason for the loss of control in order for this to be a mistake. Now, the Coroners and Justice Act 2009 has narrowed the law on qualifying triggers, and section 55 states that to be a qualifying trigger, the thing said or done must fall under one of the following three categories. This is fear of serious violence, an extremely provocative act, or a combination of the two. Now, the trigger of the fear of serious violence would apply where the defendant believed correctly or incorrectly that violence was to be used against them. Now, this fear must be of serious violence, and damage to property or minor acts of violence would not be applicable, and the threat of violence can be to another person, such as the defendant's child, for example. Now, the defendant can also not use this trigger if they deliberately attempted to get the victim to attack them in order to use their violence as a defence for murder. So loss of self-control differs from the complete defence of self-defence because self-defence is only available when the degree of force is reasonable. So this means that where the defendant could have prevented the threat by using a lesser force than killing, the partial defense of loss of self-control may be used instead. Now, the government has set out the two circumstances in which they believe that the trigger may be relevant to a loss of self-control. Now, this is where a victim of sustained abuse kills their abuser in order to thwart an anticipated attack, and where somebody overreacts to what they perceive as an imminent threat. Now, the second form of qualifying trigger is where the defendant is facing circumstances of an extremely grave character, and the defendant has a justifiable sense of being seriously wronged. So extremely grave character is not fully defined in statute, but the circumstances must have been unusual, and jostling in a supermarket or the ending of a relationship, as per Dawes, would not be applicable. So the justifiable sense of being seriously wronged is also an objective test, and it's restricted to only a few cases. So in the case of R versus Clinton 2012, it was held that the defendant must feel gravely wronged to rely on the trigger, and if the defendant was not upset by the insult, they could not rely on the trigger. So this case, which involved the murder of a wife who revealed her sexual infidelity, also determined that the defense of sexual infidelity as a sole potential trigger for loss of self-control was prohibited, provided that there were no other potential triggers as well. So the final element of loss of self-control is you have to ask, would a person with normal tolerance and self-restraint have acted as the defendant did? It must be shown that a person of a similar sex and age of the defendant with a normal degree of tolerance and self-restraint and in the circumstances of the defendant may have reacted in the same or similar way. Now this question is posed to the jury. Now the reference to a normal degree of tolerance and self-restraint is designed to prevent a defendant who has a low level of self-restraint from using this defense, and this means that if somebody with normal levels of self-control would have refrained from killing the victim, the defendant cannot rely on a partial defense of loss of self-control. Even so, if the jury are not sure whether a normal person would have acted in the same way, then the defendant should be allowed to use the defense. Now, reference should also be taken into account of a defendant's circumstances and history. For example, a minor wrong may be considered major in the light of a particular defendant's history. Now, the courts sometimes refer to this as cumulative provocation, where a long series of incidents causes the defendant to lose their self-control after being provoked by the last straw. So that is the partial defense of loss of self-control, which can be used to turn a conviction of murder into a conviction of manslaughter. So thanks for watching and see you soon. Bye.